This project is organized, this webinar is being organized as part of the VINER research project, which objective is to analyze and document how the vulnerabilities of migrants seeking protection are being assessed and addressed in certain countries, as well as how their experiences, the way they experience their own vulnerabilities, is being experienced as a result. We therefore have various partners in the project that are conducting this research in different countries located in Europe, in the Middle East, in Africa, and in North America with our Canadian partners. One of the specificity of the VINER research project is that we seek to combine legal and empirical research methods. The researchers that are involved in the project have a background in law or in anthropology or sociology. What we seek to do is to move beyond traditional legal implementation studies by having and developing an analysis that not only studies the legal framework, but also looks at the actual implementing practices and how the realities on the ground, how the experiences of the migrants on the ground are being affected as a result. By so doing, our ambition, by bridging legal and empirical research method within this project, our ambition is to have a genuine look and a real look at the way the public servants make use of their own margin of appreciation when implementing the legal framework. Our objective is also to have a look to try to understand the realities of those vulnerabilities that are being lived by migrants on the ground. It is to reflect on the complexities of the realities on the ground, to reflect on the experiences of the migrants and how they are being affected by the legal framework. How do they mobilize the legal framework, and how do they adapt their own behavior in the face of the legal framework? Our hope, our ambition by combining legal and empirical research methods within our project is to develop a fuller picture of the vulnerabilities of migrants and the way these are being developed, these are being experienced in relationship to the legal framework. We hope that in the end, this will allow us to develop a meaningful understanding of the vulnerabilities of migrants, and also to develop a critical observation, a critical thoughts on how this current focus there is on asylum policies on the vulnerability of migrants is promising, but also full of pitfalls. This approach is, however, not without multiple challenges. When trying to combine legal and empirical research methods, we are being confronted to the difficulties that are inherent in that kind of interdisciplinary dialogue. These difficulties are numerous. They often relate to the very different function that the law and anthropology, sociology, so empirical research, are trying to fulfill. On the one hand, lawyers are looking for concepts that help to categorize the reality and help to favor the decision-making process, that make a decision process that is more sound, but also more predictable. Lawyers, on the one hand, are looking for concepts that enforce and that strengthen the overall coherence of the legal system. On the other hand, empirical researchers are looking for concepts that allow to reflect on the complexities of the realities on the ground. They use different approaches, they use different conceptualization that all seek to show how complex the reality is, and that seek to encapsulate these realities in all its nuances. These challenges are, of course, very tricky for a project such as our own, which uses vulnerability as the overall framework. It requires for us to use vulnerability both as an analytical lens, as empirical researchers do, but also to have a look at how it has been conceptualized within the legal framework, where there is this search for categories that can be implemented in ways that preserve the consistency of the legal system and in ways that also offer some kind of legal certainty. I'm very pleased today to welcome two speakers to entertain us and to discuss with us about these tensions that are inherent in bridging and in combining legal and empirical research methods in the field of migration. The first speaker will be Professor Farahat. Professor Farahat is a professor of migration law at the University of Nuremberg, and she has developed already a few interdisciplinary research projects. She will discuss with us, and she will share her expertise on combining legal and empirical research methods. She will do so in a way that will also give some concrete advice on how we can move forward with this interdisciplinary dialogue. Professor Foblets, who's the director of the Department of Law and Anthropology, which is a department I'm affiliated to, will then give us an outlook of the broader discussion and the broader difficulties that can arise when combining legal and anthropological research methods. And I'm particularly pleased to have her today because she's also very involved in the WINER research project since its very beginning and since its inception. The discussions will then be moderated by Jessica Schultz, who's a postdoctoral researcher in the University of Berlin. Jessica Schultz is a member of the Norwegian research team within the WINER research project, and that research team is headed by Hilde Lieden from the Institute for Social Research in Norway. Don't hesitate to ask your question using the question and answer function that you can find in the bottom of your screen. And I will now give the floor to our first speaker, Professor Anuscheh Farahat. Thank you.
Thank you very much for the invitation and also for the kind introduction. I'm very happy to be able to give a rather brief presentation on a very complex topic today. So I will share my screen now so that you can see my presentation. Just give me a second, please. Okay. Yes, so perhaps before I start with the content of my presentation, two brief disclaimers. So the first disclaimer concerns the focus of my presentation. So I will address the question of interdisciplinary research from a legal perspective. But although I'm a migration lawyer myself, I will not focus specifically on the problems in migration law research. So I understand that this is perhaps of interest for many of you in the audience, so I'm very happy to discuss that further in the Q&A session. I have a few examples regarding migration law, but I think many of the questions are also questions that pose themselves in interdisciplinary research more generally. And the second disclaimer is that I will focus a lot of how to do interdisciplinary research and how I experienced interdisciplinary research, what I found that the interesting but also necessary practical questions are that you have to ask yourself. And that, of course, so my experiences were quite positive, but I also acknowledge that there are a lot of difficulties and challenges. Some of them I will address, but I'm also, of course, happy to go into more detail here during the Q&A session. So my first question that I would like to address is the question of how to develop interdisciplinary research designs or interdisciplinary research questions. Of course, research questions is a bit more concrete, but I decided to address those two questions here together. And I think the first question that every researcher inclined to do interdisciplinary research has to ask himself or herself is, what competences do I bring to the table? So am I a legal, a trained lawyer, so to say? Am I a trained sociologist, a trained anthropologist? What actually am I? And in what context do I pursue my interdisciplinary project? Is it a project where I work together closely and also develop the research design and the research questions in a broader group, or do I do this on my own? So so I have experience with both. And I think it's really two different types of interdisciplinary research, which I would like to present to you in the beginning. So the first type is the lonesome interdisciplinary cowgirl, as I describe it here, and illustrated with this very nice picture and the very nice sunset here. So the first question that you have to ask yourself is, if you are the lonesome interdisciplinary cowgirl, is to ask yourself what your position in the research community, but also in the research, in the research arena, so to say, actually is. So from what legal system, from what political system, from what educational background do I come? What is my own experience, my own take on the particular topic? So do I have any personal ties to the topic? So for instance, in my case, when I started my PhD on transnational migration, one of the issues that I had was to decide whether I wanted to include the example of Iranian migration, which is part of my personal migrational background. And I decided not to do that because I didn't want it to be something about my personal history, but something about migration more generally. So that's also part of the positionality that you have to reflect upon in the beginning, I think. And closely connected to that, of course, is the question of educational background. So am I a person who is trained only in one discipline, or do I, or have I studied two disciplines? So do I bring to the table also, well, interdisciplinary perspectives, in the sense that I can really know from my own educational background how the methodology and how the research interests work in two different disciplines, or even more. That is an important question, because if you, like me, only have one educational background, I'm a trained legal scholar, then you of course have to do a lot more effort to actually gain knowledge about other disciplines and gain insight about the methodology of other disciplines, and to really understand it. So that's a very important question in the beginning. And finally, if you have the background of more than one discipline, you have to ask yourself, what is the dominant discipline from which I would like to analyze this question? So should the two disciplines really be on equal footing, or do I in fact have one discipline with which I am more familiar, or of which I think that it should be the core discipline in this project? Okay, so that is the lonesome cowgirl. The second type I would like to introduce here is the cooperative team. So research in a team where different disciplines are represented by different researchers. So of course, some of them can have a double educational background, but some of them might not. So the very idea is that you somehow divide the labor, the research in the teams. So that's the core idea. What is important in these settings? I think the core thing is that you establish good structures of communication. So it's really key to understand one another and to have constant opportunities also, and venues or even routines where you practice the communication about the different methods of research, about the different approaches to a research topic, and the different research questions that might be of interest. Second, what I always found really core in interdisciplinary teams is to develop a common terminology and a common language. So very often, lawyers, and I am a lawyer, as I said, are really obsessed with concepts and terminology. So it's very important to be very precise about concrete expressions. And I think that is very important for law to operate in general, but of course it's also important in other disciplines. And very often I made the experience that if I talk of a particular concept, others have completely different associations, and they think about something completely different. And only after a while we understand that we were talking about entirely different things, while using the same word, so to say. And I think that's really important, that you're very transparent about what you mean when using a particular concept. I will come to that or come back to that in a minute. But it's really important to bear that in mind, and to try to find a common understanding, and perhaps also a common terminology. And the third point is that it's crucial to understand the other disciplines. Of course, this is also important if you are the lonesome cowgirl. But I think here it's even more important, because it's not only your take on the discipline, but it's also, in a certain way, the cooperative team is always an advantage, because you can talk to others and learn from them how they understand their discipline, what they think are the core concerns in that discipline, the core methods, and the core type of research questions. So as a lawyer, we are very much concerned with normativity. I work very frequently together with sociologists and political scientists, and they always said, well, all your questions are so normative from the very beginning. You always seem to have in mind a particular goal. So can't you just have a hypothesis or something like that? Can't you just look into the real world and try to gain some empirical knowledge before you have your normative assumptions? And that's something you need to understand, where the questions of other disciplines come from, and from what understanding and what take on reality they actually come from. So that's the second type of interdisciplinary research. Now, let me come more to the question of then really how to develop an interdisciplinary research design or research question. I think the first question here really is, what is the goal of the research that you're pursuing?
You have 5 minutes. 5 minutes.
Okay, I will manage. So the first question here is, do you want to answer questions in your own, so your dominant discipline, by using another discipline? That's a very difficult task, because you have to bear in mind that the two disciplines have different, not only different methodologies, but different research interests, different concerns also, and different goals altogether. But it's one option how to use another discipline. There is, of course, also the opportunity, something that I did, for instance, in my PhD, to use the insights of another discipline. So not to do the interdisciplinary research myself, but simply to build on the insights of others in that other discipline, and then make some use of that for your own discipline. Or if you want to answer, that is the second option, questions, research questions, genuine research questions in both disciplines. Then, of course, you have to identify research gaps in each of the disciplines, and try to ask or try to find out what they actually need from the other discipline to be able to answer that research question. So you have to do the exercise, basically, of finding a research question in both disciplines here. As I said, the problem with lawyers is that we are obsessed with normativity, and that one of the hardest things to do, and I am speaking from my own experience, is really to somehow get away from that obsession with normativity and try to really delve into other perspectives, at least for a while, before then perhaps getting back to the more normative questions. So that is how I suggest addressing the question of finding an interdisciplinary research design. What are the concrete tools that you can use if you work in a team, for instance? I think the first question that is important, is to define a concrete deliverable. I always had the experience that before you really try to nail it down, or to really define what you want to have in the end, it's very difficult to discuss concrete research questions. So the question should be, do we want to write a book? Do we want to write a research proposal together? Do we want to get funding? Do we want to publish a study? What is it that we want to get out in the end? The second important thing is you could organize conferences or workshops with mixed panels and cross-disciplinary comments. So a person from one discipline could present a topic, and the other person from another discipline could then do the comments, so that you really can learn from one another and from the different perspectives. You could also organize explorative workshops, so workshops where you do brainstorming about the research interests and research questions on a specific topic, including different disciplines. Another opportunity would be academic speed dating. So you simply sit together in a very brief session and try to update the other person about what your take on a very specific, very concrete research question is. That can be very helpful to really, to the point, talk about interdisciplinary perspectives. And you can do things like a methods interview, so interviewing one another about the methods that you use and what the problems and difficulties and the precautions that you have to take here are. I promised to get back to the question of reconciling different conceptual meanings. And I think that's very important. As I already said, I will go a bit more quickly through that slide to keep the time limit. So one of the most important things in interdisciplinary work is understanding the meaning of a concept in another discipline. So that also implies that you have to be prepared to acknowledge the advantages, but also the problems, the concerns, and the implications of a concept in the respective discipline. So to give you one example, very often when I work with social scientists, I have the problem that they think it's not so good to talk of refugees, especially in German. The word Flüchtling is quite difficult. And they start to come up with other terminologies for that. And I, as a lawyer, then always say, well, yeah, that's okay to point to a specific, for example, vulnerability of that person. But if we talk in the legal context, it's necessary to speak of a refugee because that's the legal concept to which concrete rights of the person are tied. So that is a specific meaning that, that I find is defendable. And so that's one of the examples here. But interdisciplinary research also requires you to be sensitive to subtext, to hidden messages, to stereotypes, to presumptions, and to connotations that come with a specific concept. And that is very important to find out in your conversations. In the end, I think it's also important to find pragmatic and transparent solutions, because otherwise you cannot move on with your interdisciplinary research. We can talk in the Q&A about what that could entail. Just as a last point, I would like to, almost last point, I would like to give you a few examples of how to translate research results, because I understood that it could also be of interest for the audience here. So I think one of the things is it's important to illustrate the real life relevance of your research. You need to keep the language simple if you want to communicate it to persons who are not insiders in the discipline or in the concrete research universe. I think that it's recommendable to accept interview requests to communicate with the broader public. I also believe in the value of scientific videos and podcasts. I think that's a wonderful opportunity to introduce the results of interdisciplinary, but also other research to the broader public. I think that graphic recording, a method that I only came to know myself recently, is a very interesting tool to visualize research results and also interdependencies between different phenomena. If you're so inclined, you can of course use all type of social media to publish and advertise research. But I think it's also very important to do what a very dear colleague of mine always calls Cape and Town, which is attending meetings in your own town and in the local public to talk about the research results to a very broad and non-scientific audience. So the last point I wanted to address is, can empirical findings improve legal reasoning? I think yes, they can do. They can do, first of all, by helping us to find tailored results for real life problems. Empirical research might also help us to understand how law works in practice, which is quite important. It can help us to understand context and perceptions of law. It helps us to become sensitive to obstacles to norm implementation and to understand how law produces regulatory gaps. So I really think that empirical findings can be very important for legal research, whether they are also in the same way important for legal practice is an entirely different question. So here I'm really talking about legal research. And I also think, although I'm less qualified to say that, but I also think that law can facilitate the understanding of realities for other disciplines if we understand law as a form of social engineering, as Roscoe Pound did with his famous interpretation by saying that law is a method by which means a balance between competing interests in society, then we can understand law as something that shapes the realities and experience of people, and that is an archive of social practices, political compromises, hegemonic ideology, and economic interaction. So it's really both something that shapes realities, but also that gives us an account of how reality is understood in a broader historical and societal context. Thank you very much.
Thank you very much, Professor Farahat, for this very interesting presentation with a lot of concrete tips as well on how to conduct interdisciplinary research methods. Before I give the floor to Marie-Claire Foblets, let me just remind you that you can ask your question at any time using the Q&A function at the bottom of the screen. Thank you very much to those of you who already asked some questions, but don't hesitate to send out more. I will now give the floor to Marie-Claire Foblets.
Well, good afternoon, and I also will begin, but with one disclaimer: it's time. I'm not really in the position that I can share with you what I would like to say, but let's try. And I kind of apply already the suggestion by Anuscheh. What is my positionality? In speaking to you during the coming minutes, I am convinced by the message that Anuscheh really kind of spread in the virtual room, which is, if we are sufficiently convinced that we can gain from working in an interdisciplinary way on issues of migration, there is a way. Yeah? Unfortunately, I think that my expose for the coming minutes is more to think of the hurdles, the difficulties that we cannot ignore, but don't make of me a person that does not believe, like Anuscheh, that we should give it a try, and there are good reasons to hope that it might benefit to the search for justice. That is, I think, what we share here when we think of vulnerable people. Now, I will use 6 slides, and I'm now looking for how I switch. Yeah, I will use 6 slides, and the first slide is in fact telling you the structure of my presentation. I can distribute my presentation over 3 kind of entrances, three ways to address. The first is the perspective of law and anthropology. The interdisciplinarity here is law and one specific social science, which is anthropology, social and cultural anthropology. And then use basically 2 ways to look at it. How do anthropologists look at law? And that is law in anthropology. And then, and that is the concern of today, anthropology, the knowledge that anthropologists bring in law and more particularly in legal practice. How useful can anthropology be for law and legal practice, more particularly when we think of migration law and the protection of vulnerable people? There is a third perspective, legal anthropology or anthropology of law, that is more a meta level of thinking about law and anthropology that I will not even hint at here, which does not mean that it's not a most interesting and valuable way of combining the 2 disciplines. That's my first part. The second part is, and here is this kind of the skeptical person in me today. I see so many pitfalls, so many dilemmas that come with this exercise. That is what would really make for an accurate and just apprehension of concrete situations that can be translated in legal reasoning about protecting vulnerable people. And as you will hear, I have many reasons to be very hesitant there, but don't make me conclude that I don't think it's worth really trying to have this effort as Anuscheh has presented it and operationalize. But that's what I will not do. I have the way forward would be, how do we operationalize this? I think I just benefit here from what Anuscheh said, and it will save me the minutes I need to then dig into what I would really like to focus on, and which is explain the difference between the 2 perspectives. That is law in anthropology, the first one, and then the one that will be of immediate relevance for our aims, it's anthropology in legal practice. Now, I don't know how familiar the people listening to this webinar are with social and cultural anthropology and the approach of anthropologists when it comes to law. Now, On the slide, you see the colonial heritage. The background of the discipline indeed goes back to those days that the West thought it could be everywhere and had a need to understand all these societies that in a very Eurocentric way we have been calling non-European, traditional, non-state, everything that was not what we were. Yeah? I will not dig into this, but those were the days that we started indeed being among these societies with a view to understand their functioning. Today, when you read this literature, you see the Eurocentric approach, but what remains very relevant is the way anthropologists, having been there, saw much more law than Anuscheh, you said you were obsessed by normativity. Well, yes, anthropology is also obsessed by normativity when it thinks of law, but what you mean is you're obsessed by state normativity and state-linked normativity. You're a professional of state law. What anthropologists saw is these many, many different ways societies can be legal without having a state. And their normativities are different. They might be kinship. Your society is basically based on one normativity, is the loyalty you owe to your kins. And who has no kin relation with you is an outsider to your community. So that makes up for a full normativity. Normativity being understood as what a legal system is. It's a system of binding rules of behavior. Another kind of systematicity might be ethnicity or a caste system. So there are many normativities, and anthropologists have been kind of obsessed in a way by the plurality of the normativities. What people make feel that they are not in first instance a citizen, but a kin or a believer, or the whole life being dictated by being a member to a caste. You're born in a caste, you die in a caste, and you're completely dictated by the rules of the caste. So your belonging is to be the member of a caste. And so you see this kind of coexisting of many, many normativities in societies. And if I insist so much on this, is because there are still many societies in the world, also in our societies, where all these other normativities matter much more than being a citizen to a state. And so the protection that we offer from the point of view of state mechanisms sometimes really clashes with these other loyalties. And people feel less protected than we might think by state law than they are by the normativity they share with other members of their community. And they get the support from these communities much more than they get the support from the state. And don't make me say here that this is good or not good. It's an issue of understanding, because it's only by not judging that we can better understand the behavior of people. And so anthropologists look at institutions that regulate people's life. It may be peers of elderly people, it may be religious bodies, it may be caste systems. And so anthropologists are very, very close to the people and want to understand their behavior. And for many anthropologists, this is it. And we don't have to do more than trying to understand in the full respect of the complexity in the field. And our methodologies are exactly doing that. We go for extended participant observation. We do this kind of qualitative in-depth ethnography based on long residence with the culture, with the people, and collecting information, sometimes in real confidentiality, about how they feel, how they think when it comes to law and justice. Now, to what extent can this approach, law in anthropology, help when it comes to address vulnerability in the legal practice with the search for justice for vulnerable people? And that brings me to the next slide. Anthropology in law, and in particular in legal practice. And here I have to say no consensus, neither on the side of the anthropologists nor on the side of the lawyers. On the side of the anthropologists, just to resume, as I said, some anthropologists say our professional responsibility is to apprehend and understand. It's not to participate in decision-making processes. Some anthropologists say, yes, we do have the knowledge, we should participate. And then I come back to this, we should participate, because then it comes with all the hurdles, how to participate in the legal reasoning. On the side of the lawyers, they just don't know anthropology. It's a social science. The way between law and anthropology is a way that is not even mentioned in the training of lawyers. Ask a bachelor student, what is anthropology? I mean, you very often, they don't even, not even as an optional class. So how would they think of anthropology dealing with issues that could be relevant for law and legal practice? And then we come to the question, when we then have a discussion with one another, we disagree on so many things, because what is relevant for the anthropologist is not necessarily what makes the relevant question for the lawyer. As I said, the anthropologist tries to understand. The relevance comes from the field. For the lawyer, the relevance comes from the legal question. What is just will differ fundamentally depending on which normativity you are in. The same, what makes for a contentious practice? We anthropologists are very often taken for people that are everything goes people, because we are cultural relativists. Everything is fine. That's not the position of an anthropologist. But it's not because we do not label practices that are clearly clashing with human rights that we agree with these practices, but we will not label them contentious. We will try to understand them, and we will try why they are so persistent. Anthropology at the service of decision-making, as I said, some will say no. Why? Because we disagree on all these questions. Yeah? And then some anthropologists, and frequently anthropologists are nevertheless in this application, and then there is the difficulty of these hurdles. If an anthropologist takes really the position that his knowledge can be useful for lawyers, then we really sit around the table that Anuscheh designed so nicely on one of her slides. But there is so many that will make us not speak the same language. And because each of us has his or her professional responsibility and should stay with that responsibility. If I go to a lawyer, I don't want him to criticize the state law. I want him to know the law, and I want him to apply that law for my case. So the lawyers have to work with state law, even if they see the limits of it. An anthropologist has a completely different way of thinking. So he's not normative. He is dealing with empirical data. The lawyer is per definition deductive in his thinking. An anthropologist can't but be inductive. The sense comes from the detail of the empirical field and then put in the broader context. For an anthropologist, there is no precedent. The precedent is the behavior of the people, and if it turns out to be a precedent, it's because the people behave conformingly. But for the lawyer, the precedent is, of course, it's part of the rule of law. You do not overrule that easily. You are bound by precedents, and that makes the legal security. So in-depth expertise in anthropology versus universalist approaches by lawyers, again, makes us speak different languages.
Marie-Claire, you're at 12 minutes.
I try to make the best of it, but if it is to just feel that I am too skeptical, I better stop here, because I have a number of other hurdles to be mentioned. On the side of anthropologists, maybe there is also this problem to be really understood in terms of science by lawyers, is that anthropologists traditionally have been studying groups that we could consider today vulnerable people. Vulnerable from the point of view, very often, that they were not around the table when all types of solutions or all types of mechanisms were discussed that regards them very directly when it comes to land, when it comes to migration, when it comes to participation in political systems. They were not around the table. And so they are not protected the way they would understand what protection is by the state legal system. And so anthropologists, for having been very often on the side of these people, it's very difficult to stay objective. You become very often engaged. And engagement, not because you're not a good scientist, but because you want to raise a voice that the people do not have. And so you become very often the spokesperson of these people, and you also start defending their interests. And then very often the anthropologist is perceived as being too militant, too biased, not to be trusted. So there again, the engagement that comes from the historical setting within which anthropologists very often have been working and dealing with minorities makes them to some be too engaged to be scholars in terms of scientific researchers. So the principled approach on the side of the law, summa jus, summa injuria, I mean, it may be very unjust, but since it's the law, a principled approach makes you apply the law. I mean, look at what an anthropologist will think of this. He said, you're completely crazy. I mean, put this principled solution in the context and you have no solution. So the more I think about my skepticism, the more I think, how will we overcome all these hurdles? And I think we have, and I follow Anuscheh there, we have to be voluntaristic in our approach. There are illustrations of success where you have an expert sitting on the side of the lawyer and giving him the right information just to do the search for justice, in the sense that it leads to sustainable justice. But if I'm honest, it's more the exception than the rule. And as I said, there would all kind of small things that need to be installed. Put a class of anthropology in the training of lawyers. Do it at a very young age when they begin. Then they already feel that state law is a professional skill, but that does not cover all aspirations about justice in the world. And you can maybe bring something of these kind of different ways of thinking of justice in comparative law, but comparative law is still very much state-linked law. So when then anthropologists really decide that they will give it a try, let me then give you a few illustrations of how difficult it is for an anthropologist to be a good expert at the service of decision-making. A good anthropologist is an anthropologist who is in the field and stays in the field. So to update his knowledge, an anthropologist is very often not around. An anthropologist has to return very regularly. You don't make a business of expertise by staying close to the court. You have to return very often in the field. And then what you have is the kind of knowledge, the way you collect the knowledge, that is this relevant knowledge to understand the behavior of the people. Why do they stick at practices that clearly clash with human rights? You can only understand that by speaking with the people, by understanding why they have more to lose by claiming protection of some human rights than to gain. I could give many examples of discussions of anthropologists with mothers that keep practicing female genital cutting to their daughters, and they tell you that they know that it's not a universal practice, but they fear so much that in the case that is the case of their daughter, they would not abide by the practice. They would not have been a good mother. And we could give so many other examples. It's the belonging that matters. It's not the human rights. When an anthropologist collects these testimonies, these are testimonies in full confidentiality very often. He will not feel that he can disclose this without knowing where it lands, on which table of which decision maker. In anthropology, we are now following what in social sciences has become a good practice, which is to ask for the consent of your respondent. I mean, how can we ever think that a person knows what he or she is consenting to? Very often people who really don't think that it is the right way to protect yourself. It's to consent when a person asks you questions about your deep intimacy, your deep belief. Anthropologists will contribute to the vulnerability of the people if they disclose some data that do not suffer really publicity. So for an anthropologist who knows that the knowledge he has can be very valid when switched into a decision-making process, these dilemmas are there, very much there. And then to have really a good relationship between an anthropologist and a lawyer, as I said, anthropology is an unknown discipline. Very often judges might say, well, if I find the right expert, please, but who are these people? Where do I find these people? Databases of social anthropologists are very rare. There are some, but when I speak for countries like in Europe, I don't see where a judge would kind of find information about what could be an expert. And then there is the question, who will pay for the expert? Sometimes you see really anthropologists who accept to do this kind of work in terms of participating in litigation, but very often they do it because they see that there is a priority that makes them do a right service to a cause, a very, very specific case. But sometimes anthropologists will say, I accepted to just be the expert in a case, but then I saw that the priorities that were put in that case were not the priorities that I was putting, and then they feel a little bit instrumentalized. Or the other way around, since I'm an anthropologist, I'm supposed to give cultural relevance to a practice, at the risk that for finding something anyhow cultural, you culturalize a practice and you make of behavior something that was not necessarily seen by the people as their culture, but since you need, for the sake of the argument, a cultural argument, you make of it a cultural argument. So all this are hurdles, all this make that for anthropologists to accept to participate in decision-making processes with a view to improve the process, which is to find sustainable solutions that protect vulnerable people. There is a lot for an anthropologist to think through. And I think I will leave it by that so that there is more time for a little bit of questions. I hope that's fine with you. Emily? Okay, then I stop here and I save you the effort of having to look at the last slide, but you can have a look at it. Yeah.
Thank you to both speakers for what were truly, truly fascinating presentations. Gave us a lot to think about, and also some tips about practical ways forward, as well as some of the challenges of collaboration. I know I have a lot of questions myself, and I encourage everyone who's participating in the webinar to add their questions to the Q&A at the bottom of your screen. Maybe we could start with one question by Miriam. She is going back to Anuscheh's presentation and wanted clarification on what is meant by tailored results for real life problems. And maybe that's also a way of asking whether real life problems can be channeled into a single disciplinary research question. In a way, we talked a lot about sort of using the insights and methods from one discipline to inform the research questions sort of set by another discipline. But, you know, is there a way to think about research questions in a more coordinated way? I'm not sure, Miriam, if that's what you're getting at, but perhaps that's something that also follows along from that question. So I'll let Anuscheh. Yeah.
Can you repeat? I don't think that I got the second part of the question. So what you meant with more coordinated way of?
Well, I'm wondering
how the different questions link or somehow link to one another.
Yeah, is there any way? Well, this is a real question that I struggle with in my own research. Is there a type of interdisciplinary research that seeks to identify questions that resonate in with more than one discipline, rather than what I kind of understand to be the dominant approach, which is taking, using methods and using insights from another discipline, whether you try and adapt those yourself or whether you rely on colleagues in a project, for example, to answer questions that are kind of developed through the lens of your sort of dominant discipline, if that makes sense.
Yeah, makes sense. Yeah, so I go to the first part of the question first, and then I will come back to your question. I think what I meant with, tailored solutions for real life problems is that very often lawyers tend to develop very nice legal buildings and legal concepts and procedures, and they simply don't recognize and very often don't even know about the obstacles in practice. Or they very often don't know about what, for instance, the driving mode. Let's take an example from immigration law. They don't know a lot of what motives are actually driving migrants to decide to cross the borders and to leave their countries. They simply assumed something, and then they assume something about push and pull factors, but they have never seen an empirical research about that. But they build legal rules on that. And what I mean by more tailored solutions is, before designing a new legal provision, it would be useful to get a more comprehensive and more in-depth understanding of the phenomena I want to regulate. So that is what I meant here. And the other question, yeah, that's indeed the $1 million question that you're searching for, a research question that in itself speaks to different disciplines. I can, maybe I can give one example where it is at least close to that. So if you ask the question whether a particular change in society or in public discourse or in legal reality results in changes of, it results in power shift or in new agency. I think that is a question that you can address from different disciplines, because you can address it from a more social science perspective, where you really look into the practice of power and how they how an institution, for instance, uses its competences. But you can also look to that question from a legal perspective by identifying the formal competences and the so to say the legal opportunities to gain agency and to analyze that. So there exist questions like that, but when you concretize them, you again take the perspective of a particular discipline. So I think it's an overarching question, but when you really want to do the research, then you need to come back to a disciplinary perspective, at least for one moment, and then you can put that in the perspective of the other discipline.
Thank you. That's really helpful. I noticed that there's a question from Sarah, who asks whether you have experience, I guess this is to either speaker, in formulating research questions together in dialogue with your participants. Perhaps actually I should ask Anuscheh to think about that first. I guess in some of your collaborative projects, have the research questions been designed together with people from other disciplines, and also with potential participants in the research?
So by participants, it's meant other researchers, or?
As I understand, perhaps, for example, doing migration research in dialogue with migrants or people.
Okay, yeah. That's an easy question. I have no experience in the latter, so I have not done any research together with where I developed the research question together with, so to say, the objects of the research. I have experience in developing it together with other disciplines, so that's what I did in my DFG project on transnational solidarity conflicts, where we tried to understand the dynamic of the conflicts that resulted from the Eurozone crisis for constitutions, both from a social science perspective and from a legal perspective.
Great. Here is another question for you from Petra. I am a lawyer myself, and
Don't you want to give Marie-Claire the opportunity to answer that question?
Yes, sorry, Marie-Claire.
It's just to share a very recent experience where the research question indeed was phrased in a way that it came from the German judiciary, who was really kind of wondering about the why some communities stay systematically away from state court justice. And it was just a why. And, you know, of course, their concern was, do we fail in terms of offering a public service? And what makes them stay away? And this was a very open question, and sufficiently open that we accepted to take this as a responsibility to be documented in an empirical way. No prejudgments, just the why. And then the whole kind of difficulty has been find researchers that can do it in the way that I said, which is that they're sufficiently close to these communities. It begins by speaking their language. Find these communities, because that was also not predefined. We know many communities stay away from state court, so we couldn't cover them all. And so then we found, after 3 calls, I mean, we had to really publish the position 3 times, then we found fabulous researchers at postdoc level who then found highly interesting experiences and that have nothing to do with not wanting to call upon state justice in Germany, but that has a lot to do with the previous experiences of justice in the country of origin and the staying very, very much connected, rooted in their thinking about justice with these communities. And that, I think, is a very valid research, because it comes from a kind of need, but we only accepted it because it was formulated in an open-ended way. And then it turned out that it produced new dynamics. What we now do, and it is very nice, is we participate in the judges' training in Germany. The Deutsche Richterakademie has a kind of program on cultural diversity in the courtroom. And you know, that's also very interesting, because you then see these judges that have the experience of diversity, and sometimes, so it produced in the end something very constructive. But I begin by saying it was only because the question was put in a very open-ended way that we felt sufficiently confident to dig into this question. And that's a reason. And then we will have a conference in April next year. It will probably be virtual, where we submit, so to say, the findings. And I hope that we have an audience of judges to listen to these findings. Yeah. So that's really a question that came out of a concern from one discipline and then being addressed in another discipline.
Really, really interesting example. Thank you so much. Do we have time for one more question? We have 3 minutes. Here's a question. I am a lawyer myself, and I do empirical legal research within an interdisciplinary research group. Basically, I'm interested in how courts are challenged by or use the concept of gender in the face of crises. To answer this question, I analyze rulings in the field of migration and environmental law. Basically, I could very much relate to your presentation, Anuscheh, especially to the idea of lawyers being obsessed with normativity. My question, what are your thoughts on turning normativity into a research object by focusing on legal doctrine? Could this be a valuable strategy?
Yeah, it's a hard question. I think I will answer on 2 levels. I think the first level is that if you apply a critical legal studies perspective, one thing that you can do is you can try to use the insight, or if you're sufficiently trained, also the methods of other disciplines to try to find out what implications the use of legal doctrine and of the implied concepts have in practice. So where do they exclude persons? Where do they convey a specific concept underneath, or specific principles underneath that are not made explicit in law? Where are they influenced by stereotypes and dominant views in the society? So that is a technique, I think, a legal approach that can be very useful to identify those problems in legal doctrine. But at the same time, I think, while that can be very useful, if you then want to draw conclusions for the application of the law, or for the development of the law, if you want to propose something, then you need to get back to the legal thinking again to make a solution that can also be built into the language of law, so to say. And the second part of the answer would be, of course, I think Marie-Claire will agree with that. As an anthropologist, you can, of course, also look at legal doctrine from an entirely different perspective, as a cultural phenomenon of, in particular, Western, but not only, societies where state law plays a specific role, and which basically represents our way of organizing and ordering societies. But then it's more a cultural phenomenon. So that's different, I think, to a lawyer's approach to that.
Thanks. There was another question. We'll just go 5 to 10 minutes over, if that's okay. And we have a lot of good questions suddenly coming in. Whether a governance framework more focused on local area governance in place of empowering federal laws can lead to more cooperation between normativity and empiricism. Yeah, I think I understand what that question is about. Is that something that either of you have any thoughts about? Whether if we shifted focus to local area governance, that would be a more sort of natural grounds for merging sort of normativity and empiricism.
I give it a try, but it might be not having. I'll give you a very recent example. Today, we have the press release of a research that we have been working with 6 Max Planck institutes on. By the way, Luc was also involved in that research. And it was about how did Germany address, since 2015, the question of the newcomers, and what are the mechanisms of inclusion and exclusion. And because you speak of these local governance, one finding is that there is a lot of creativity at the level of the local, the municipalities have been showing extremely kind of creative, but that it is rarely kind of noticed. And so you could really gain by looking at how at local level, and of course as an anthropologist, I always prefer the bottom up than the top down, but here the bottom up really showed, and what you then sometimes regret is that these civil servants, or those people who did this kind of daily creative way of dealing with what was a challenge, if it only were the numbers, the language skills that were not there, the desperation of the people that didn't know exactly how to properly behave, and they wanted to properly behave, how this is very often ignored as not being sufficiently leading to sustainable solution. It did. So I really think it's when I did correctly understand the question, if you look sometimes at local before you look at upper, you get a kind of different picture, and it might be less dramatic, or it might be more encouraging. And these kind of observations were done by anthropologists who have been speaking with these people at municipal level. And so I hope that the person who raised the question, whether it resonates to her or him, I don't know, but that was my answer to this question.
Thank you. I think actually that's a great way of sort of rounding off the webinar, because you kind of point out again that the fact of how local bureaucrats and others are using their discretion is itself a legal question, as Luc brought up in the beginning of the webinar as part of his introduction. So I think that this conversation needs to continue, obviously, and I'm really sorry to those whose questions we weren't able to cover, but I'm sure that any of us are happy to speak with people individually if they're interested. So on behalf of Luc and the Vulner Project, thank you again for attending the webinar, and please share it broadly with your colleagues and friends when it's online. Thanks a lot.
Thank you.